And Mr. Zapata's here. You're already under oath. Thank you, sir.
Right out of the gate, notice how fast this is moving. When a defendant is already under oath and waives formal readings, that's usually a sign a plea deal is locked in. No trial drama, hear this, is damage control mode.
Good morning, ma'am. Are you Maria Gutierrez?
Maria Gutierrez? Yes.
And Mr. Parker, will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Gutierrez, in cause number 25, DCCR 1120, you're charged with the state jail felony offense of theft of property from May 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker and the translator?
Yes.
Do you fully understand those documents?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen,
This part is huge and often overlooked. The judge is legally required to warn about immigration consequences. A guilty plea doesn't just mean jail time. It can mean deportation, denial of citizenship, or never being allowed back. Pause for a second. Would you still take the deal knowing that
a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Gutierrez is not competent?
No, Your Honor.
months in state jail may sound straightforward? But here's the twist. Because this is a plea agreement, her right to appeal is gone. That's the trade-off. Certainty now, no second chances later. Was it worth it? Drop your thoughts in the comments.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. And at this time, find you guilty of theft of property. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you an admonishment regarding your ineligibility to possess a firearm or ammunition.
And just like that, one case ends and another begins. This courtroom doesn't slow down. Watch how quickly the focus shifts from a clean plea to a defendant staring down trial time with zero deal on the table. Completely different energy.
Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. The admonishment is in Spanish. You should read it carefully. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, you should ask Mr. Parker.
arma de juego como un tipo de arma o pistola. Sí, no puede tenerlo usted.
All right. Thank you, ma'am. Good luck to you. You can go back with the bailiff.
Es todo, gracias.
Okay, so you're Jacoby and Dorsey.
This is a critical moment. Refusing a plea in one that runs concurrently with an existing sentence is a serious gamble. The judge even offers a new attorney to speed things up. Translation, trial is coming fast. Would you roll the dice?
All right, and was there any additional negotiations?
Just for the record, Judge, I've asked him without talking to Mr. Coleman if he would take the 20 years if it wasn't stacked. He indicated that he wouldn't. Mr. Coleman kind of implied that he may offer that, so I didn't know if you want to change that, but it hasn't really been an offer of that. But
all right, so Mr. Dorsey, it sounds like even if it was a sentence that would run concurrently at the same time as that 30-year sentence that you're serving now, or could be serving if the appeal is affirmed, that you don't want to take any offer or a plea on this case. Is that correct? All right, then what I'll do is get your case set for trial. Mr. Dorsey, Mr. Parker has been appointed to you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him, and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Yes, ma'am. All right, we'll get that done. Mr. Parker, you're released, and Mr. Dorsey, someone will be appointed today. They should be out to see you very soon to begin preparation for trial. And do y'all know how long the appeal has been pending? Do y'all have any idea?
It's been a couple months at least.
Okay. It was out of the other court though, right?
Yes, ma'am.
Okay. All right. So if y'all get any information on that, if you'll just let me know, it'd be nice to have that potentially by the time we go to trial, but we'll see. All right. Thank you, sir. You can go back with the bailiff.
and I think that rep Rice hired on that David Greer.
Good morning. Are you Dakota Coon? And Mr. Lewis, will your client waive the formal reading of the motion?
Multiple probation violations, repeated positive drug tests, and new charges. This is the nightmare scenario for deferred probation. Once you admit these violations, the court's hands are basically untied. Probation isn't a warning anymore. It's a countdown.
He does it.
Mr. Coon, in clause number 23, DCCR 0968, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 1st of 2024 for the lesser offense of attempted assault on a family member by impeding breath or circulation, state jail felony, and that was a 2-year deferred probation. Is that correct?
Sure.
And then count 1 alleges that you violated your probation. It alleges that you committed the new offense of possession of a controlled substance May 12th of 2025 in Chambers County, Texas. And is that true or not true?
True.
Count 2 alleges that you violated your probation by possessing a drug, cocaine, at the time of that arrest on May 12th in Chambers County. Is that true or not true?
True.
Count 3 alleges that you failed to never become intoxicated in that you provided a urine sample April 30th of 2025 that tested positive for cocaine. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample May 9th of 2025 that tested positive for cocaine. Is that true or not true?
True.